And you can just sit until I call you up to the podium, you know. Okay, everyone, we're going to go ahead and get started again. I know several people are still in the exhibit hall, and they'll be slowly trickling in. Kate went to make an announcement, but I don't want to fall too behind our schedule and want to give you all time to get to the beach because it's beautiful out there. So welcome back, everyone. I hope you got some snacks and coffee and got to meet with the vendors. Please go see them again after we're done for today so that they know how much you appreciate them being here. Our next speaker is Mr. Slade Edwards, who is yet another personal friend of mine and the husband of one of my former top medical students and top residents, Dr. Martha Cohen Edwards, who's sitting up front here. She used to help me here at this conference when she was a resident. So, Mr. Edwards is partner at Moody Legal Counsel. He graduated from the University of Georgia, go Dogs, with a bachelor's of business administration and a major in risk management. After college, Mr. Edwards received his law degree from Mercer University's Walter F. George School of Law. In law school, he was lead counsel for both the moot court interstate team and the school's team that competed in the nationwide American Trial Lawyers Association competition. He also received the award for outstanding achievement in legal writing. After law school, Slade, I knew I was going to slip and call you Slade, it's fine. He's my friend, I'm going to call him Slade, right? Slade accepted an associate position with Martin Snow in Macon, Georgia, where he specialized in defending insureds from personal injury automobile cases. In 2008, he accepted a position as house counsel for Progressive Insurance Company, where he was promoted to manager in his first year. After 4 years of managing their Macon office, he returned to Martin Snow and joined the firm's MedMal practice section. Mr. Edwards has obtained defense verdicts on behalf of every healthcare provider he has defended through trial. He has never lost a MedMal practice trial. Mr. Edwards Mr. Edwards made partner at Martin Snow in 2014 and became the lead partner chairing the MedMal practice section. In 2020, he joined Moody Legal Counsel, where he now represents plaintiffs in personal injury cases identical to the cases he spent 16 years defending. Mr. Edwards' experience and success in defense of healthcare providers uniquely qualifies him to represent victims of med malpractice who have legitimate claims. He has worked for all the major insurance carriers in the field, and he knows expert witnesses in nearly every medical specialty. Please join me in welcoming Mr. Edwards as he talks about navigating legal battles in the medical world. Welcome, Slade.
Good morning. It occurred to me when you looked at your agenda for this weekend that you probably saw a lawyer was coming to talk to you, and you were wondering what that was about. As Dr. Woodham has said, and thank you for that kind introduction, I call her Champa, y'all. She's like family to me, but as Champa said, the biggest part of my qualifications to be up here talking to you all is the fact that I'm married to the best OBGyn in this room, Dr. Martha Cohen. Martha and I met in her second year of med school, and so I wasn't on the ground floor level of this journey that she's been on, but I was pretty close. I was there for the last 3 years of med school and basically step 2 all the way through residency to her recent board passage. So I know what all of you have been through to become OBGYNs or to become physicians. I know how challenging it is. My wife also made me a father. We have 2 little boys, and Champa's husband has been grateful enough to watch them at the pool while I give this presentation. But she's an amazing woman. She's a beautiful woman inside and out. She's a successful woman. And so it was just one of those things that was serendipitous in life that I was defending healthcare providers when I met her. And I think that helped me trick her into marrying me, honestly. And, you know, occasionally in your professional career, you intersect with somebody either through your own path or your spouse's path that you have an immediate affinity for. And that happened with us and Champa and Darren. We consider them super close friends. In fact, we talked about this last night briefly, but Champa is the reason that Martha is an OBGYN. Martha was probably headed towards dermatology, and she delivered a baby with Champa. The story goes, Champa thought she was very skilled and wanted her and to be a resident. And for those of you that know Champa, Champa gets what she wants a lot. And the other part of that story that is undoubtedly the reason Martha is an OBGYN is that she was thrilled by bringing a life into this world. She came home and told me that day, that was the greatest thing I've ever done. I think I want to be an OBGYN. And off we went. So started coming to this event years ago. Well, let me back up. So Champa asked me to give this presentation to their residency class when Martha was in her last year. And I started coming to this event after that and realized very quickly that Champa was going to be running this thing one year. And certainly that happened, and Champa reached out to me and said, would you come give the same presentation that you gave to us in residency to this group? And no questions asked. If Champa wants it done, I'll be happy to do it. And so that is why I'm here. I learned while I was here, and I hate to have learned this probably after most of you all, but I've learned that Dr. Bick was on the planning committee, and he is the one that planned this here. So the way that works is you might be on the planning committee, and you may be signing contracts for events that take place at venues 3 and 4 years down the road, and Dr. Bick was the one that signed the contract to have this event here. And then Champa stepped into her role and has made sure that this event here has gone in accord with his wishes, and make sure that this event has run very smoothly. Dr. Bick was important to my wife. She thought very highly of him. Any of you all that had the pleasure of getting to know him or meet Dr. Bick, he was a very kind, very gentle, very caring man who cared about his patients, but also cared about this community of folks. So when you're walking around this weekend, if you have the occasion, you know, try to remember Dr. Bick. Try to carry that in your heart this weekend. He was a good man. Okay, so without further ado, and I may leave the podium here in a minute if I get kind of cabin fever stuck behind these things. I will start here and we'll see how it goes. If I come down here, can y'all hear me, or do I need to stay here behind the microphone?
They want you to stand on the mic.
Okay. Check. Okay, perfect. Can y'all hear me okay? Okay, so this is the overview of the presentation. I'm going to talk to you all about the elements of a medical malpractice case, what all that involves. I'm going to talk to you about the threshold requirements of a plaintiff patient, which I heard the air kind of go out of the room when everybody heard that's what I do now. I represent plaintiff patients, but for the bulk of my career, I was an advocate for folks just like you. So I've been at this for 20 years, roughly 17 of those. I was advocating for healthcare providers and advocating for physicians, and specifically advocating for OBGYNs a lot. I believe that I'm uniquely qualified to tell you all how to protect yourselves, what to expect if you do get sued. You're going to get sued at some point, by the way, just know that. because I have experience on both sides. And so I think the experience in defending these cases will help me, help you all today, and I also think my experience I now have on this side of the plaintiff side will help me. We're going to talk about the statute of limitations. There's some unique parts about the statute of limitations that apply to OBGYNs that we'll go over. We'll talk about pre-suit demands. We'll talk about consent to settle. We'll talk about pleadings, trial procedure, and then we'll kind of get to what almost everybody wants to know is what can I do to protect myself. We'll talk about that a little bit, and then we'll do a couple case reviews. I've got 3 cases in here. There are cases I defended years ago that I'll tell you that one of them is so long ago I can't remember what happened. So we're going to skip over that one, dating myself a little bit. But we're going to go over a couple cases and just tell you the facts and maybe let you try to, maybe some people will volunteer to share with us what you think maybe the outcome of the case was, and then I'll tell you whether or not you were right or wrong. So this is what I call torts 101. Every tort case has 4 elements. It's not different in a medical malpractice case. You have a duty. Just by the fact that you all are healthcare providers, you create a patient-doctor relationship with everybody that you treat, and that duty right there is inferred, right? So you have a duty the minute you take on a patient to treat that patient within the applicable standard of care. We will talk about what that standard of care is here in a minute. In a medical malpractice tort case, you have to prove that that duty that's inferred was breached. And then you have to prove that what that is defined as in medical malpractice terms is a breach in the standard of care. That is a fancy term for negligence, okay? In a automobile case, if somebody runs a red light and T-bones you, they were negligent when they ran the red light. In a medical malpractice case, if you deviated from the standard of care or you breached the applicable standard of care, you were negligent. So that's just a fancy term for negligence. Then you have to prove that the aforementioned breach or negligence caused injury, and then you have to prove that those injuries caused you as the plaintiff or the patient to incur damages. So in the law, we talk in a lot of language that doesn't make sense. I don't know how many of you actually know this definition, but this is the actual legal definition of the standard of care. It's what a reasonable physician would do under similar and like circumstances. So you are all required to practice within this applicable standard of care, which means you have to be reasonable. Anybody want to guess whether or not that's a local or a national standard? Okay, so I heard a little bit of both, and I think everybody's right. It's a national standard, meaning this is the definition of it across the country, but it's somewhat localized in the sense that what is reasonable for you or what is reasonable for a doctor maybe in Valdosta, Georgia, may not be the same as what's reasonable for a doctor in Atlanta, Georgia, just by virtue of the fact that you may have different capabilities, you may have different technology. And so the standard of care is defined the same nationally, but it's somewhat localized because what's reasonable for you is somewhat determined by where you're located and what you have access to. Okay, how does a plaintiff prove that a healthcare provider breached the standard of care, or as we're here today talking about OBGYN specifically, how would a plaintiff prove that you as an OBGYN breached the standard of care? There is only one way, okay? It has to be done by expert testimony. So medical malpractice cases are unique in the sense that they require expert testimony, okay? If you were involved in an automobile accident, you can go in court. You could do it without a lawyer. I would never recommend it, but you can go in court by yourself or with a lawyer, and you can say that person ran the red light, and when they ran the red light, they hit my vehicle. When they hit my vehicle, this is what happened to my body. These are the injuries I sustained. These are the places I went to treat for my injuries, and you can submit your medical bills, and a jury can give you a verdict based on that alone. Not in medical malpractice cases, okay? You have to have an expert that will testify under oath that the conduct that occurred was a breach in the standard of care. And that expert has to say that opinion within a reasonable degree of medical probability. And the expert has to give the opinion within a reasonable degree of medical probability that a breach occurred and that the breach caused injury or damages. You do not have to prove the amount of your damages by expert testimony, meaning you can just admit your bill. So if you have to have what we call a revision surgery, or if you have to have some treatment that you otherwise wouldn't have had to have except for the malpractice, you can just testify as, a plaintiff can just testify as to those bills and the amounts of those bills and get those into evidence without expert testimony, but everything else requires an expert. The reason for that, as you all probably have ascertained here, is if you didn't have that, what I call a barrier to entry, right? If everybody could just take their case to court against a medical provider, all of you would spend all of your time defending frivolous cases, and you wouldn't have any time to practice medicine, right? And so the legislatures, and this is in every state that I've ever practiced, came up with this: how can we protect healthcare providers from frivolous claims? And what they came up with is, well, you have to have an expert sign an affidavit to attach to a complaint that says this was a breach in the standard of care. And they also put these conditions on what that expert must meet from a qualification standpoint. The expert must have been licensed in the field in their state during the time the alleged malpractice occurred, okay? This is designed, in my opinion, this is the legislature saying we are not going to let healthcare providers retire early and become professional experts and make a bunch of money doing nothing but criticizing other people, okay? If you want to be an expert and you want to criticize the care that somebody else rendered, you have to be licensed in the field that you are criticizing. You also must have been practicing in that field for 3 of the past 5 years, okay? This is the legislature saying we want current physicians, people that are up to date on technology, people that are up to date on the literature. We want those people criticizing folks in medical malpractice cases. We don't want professional non-practicing experts, okay? This is your state legislature trying to protect you, okay? And it's important who you vote for and who you have in the state legislature, right? These are laws that were intended to protect our healthcare providers. The final requirement is the practice in that field must have been sufficiently frequent to establish an appropriate level of knowledge to diagnose and or treat the condition. We see in cases all the time overlapping things, right? So you might have a case against a family practitioner that involves some sort of gynecological care, right? And so maybe you want to use an OBGYN to criticize that care as a plaintiff or a patient. You can do that so long as the OBGYN's practice, what you're criticizing, overlaps with what the family practitioner was doing and what you're criticizing the family practitioner over. This is a federal case, this Daubert case, and it's one that every law student in the country has read numerous times and is very familiar with. But if an expert is giving a scientific opinion, it has to meet the thresholds of this Daubert case. And I'm just going to read through these for you. You don't need to get bogged down in this law, but the testimony must be based upon significant facts or data, meaning the expert must have actually reviewed the chart and have the information available to the expert to give the opinion. The scientific principle and method that the expert uses must be considered to be reliable. A lot of times you meet that reliability prong by having things peer-reviewed, right? If it's a peer-reviewed type thing, then that usually will check that box. And then the expert must have applied the principles, whatever the scientific principle or method is, those must be applied reliably to the facts of the case. If you cannot have your expert meet all of these, you're going to get what's called a Daubert challenge in court, and the judge is going to deem your expert is not competent to provide the testimony for which you are calling your expert. And when I say you, I'm talking about the plaintiff patient, okay? So if I were to retain an expert that gave a scientific opinion based on the care of an OBGYN, the other side may make a Daubert challenge to that expert, an attorney for the OBGYN, and if I cannot meet these elements, I'm going to lose that argument, and my expert's going to be deemed unqualified to give those opinions, and the case is probably going to be dismissed. Okay? Again, this is not the legislature, but this is the court system coming up with rules to try to protect you all, right? They want the people that are engaged in this business of criticizing other physicians to be qualified, both the legislature and the courts. All right, so as I talked a little bit earlier about the reason we have this, again, it's to protect you, right? It's a barrier to entry that basically you don't even have the right to be in court if you can't find one of these experts to give this opinion under oath. So in every medical malpractice case, you must, or the plaintiff must, attach an expert affidavit to the complaint. And that affidavit is going to set forth the expert's background. Typically, you'll see the CV attached to that as an exhibit, but it will set forth the expert's background. And then the expert has to give an opinion as to at least one violation in the standard of care that occurred in the case. And then the expert must meet all the other qualifications that we talked about in the prior 2 slides. But in every case, medical malpractice case, you are going to have an expert affidavit attached to the complaint. There are a handful of situations where you can file a complaint without an expert affidavit, and the plaintiff can plead that the plaintiff's lawyer can plead that the client came to them so late in the process they haven't had time to get the expert affidavit, and you can make that pleading. You can get like an additional 90 days. But eventually, every lawsuit in the state of Georgia is going to have an affidavit attached to it from a qualified expert pursuant to this statute, or the case is going to be subject to dismissal. Okay? Again, that's a protection for you all, right? This is your legislature actually coming up with a code section that says you have to have an expert affidavit attached to a complaint, or you don't have the right to be in this courtroom. Okay. Statute of limitations in Georgia in all tort cases, if you were to say, what's the general statute of limitations? It's 2 years from the date of the incident. So in a car wreck, if you're involved in a car wreck, you get 2 years from the date of the wreck to file your lawsuit. In a medical malpractice case, it's generally the same thing. The plaintiff patient has 2 years from the date of the alleged malpractice to bring a case for malpractice, subject to some exceptions. In a foreign object case, if you all were operating on somebody and there was a bad sponge count or something and a sponge was left behind, that 2 years would not start running from the date the sponge was left behind. And if you think about it, it makes sense because the patient doesn't know the sponge was left behind. So it would be unfair to the patient plaintiff to say, well, you didn't discover this until 2 years after the fact, so your claim is dead. So what the legislature has said is you get 1 year after the negligent act is discovered. So let's say a sponge is left in me 3 years ago. I learned about it yesterday. I get 1 year from yesterday when I learned about it to file my suit. There's some what we call tolling issues with the statute of limitations. If you have a medical malpractice case that results in a death, you essentially have 2 cases. You have an estate claim and you have a wrongful death claim. The estate claim is 2 years from when the negligence occurred. The wrongful death claim is 2 years from when the person died. So you could have 2 different statute of limitations involving the same case and the same care, and then the actual statute of limitations on the estate side may be tolled until the estate is represented, meaning you don't run the clock on an unrepresented estate. You have to get an administrator appointed, and then the day that happens, the 2 years starts to run. If a plaintiff is mentally disabled, the 2 years doesn't run until that disability is deemed by the courts to be removed, or they become non-disabled. And then you have, this is what really applies to you all as OBGYNs, because you're dealing oftentimes with newborns, right? So the 2 years for a minor's claim doesn't start to run until the minor turns 5, okay? So you have a shoulder dystocia case, right? Baby gets stuck in the birth canal for a while and the baby comes out with some neurological deficits. When the baby turns 2, that claim is not extinguished, okay? That claim is only extinguished 2 years from when the baby turns 5, right? And that is just the law trying to recognize that we don't know all the time if those neurological deficits are going to return, if they're going to be permanent. So we're going to give folks a little bit more time to figure that out, okay? That's all that is. But that is very applicable to you all as OBGYNs, right? And I tell you all that just to tell you, if you have, like, and I'm just using shoulder dystocia because it's a good example, but if you have a difficult shoulder dystocia delivery, right, and you have a baby that's born with some sort of neurological compromise, you can't breathe a big sigh of relief at the 2 year mark, Okay, the big sigh of relief for you is at the 7-year mark, 2 years after the baby turns 5. Georgia also has something called a statute of repose, which means you have 5 years to bring all cases regardless of the statute of limitations, okay? That is just the legislature trying to say we are not going to have healthcare providers defending cases that happened 10, 15, 20 years ago, okay? So you've got 5 years to bring any case. Much like I was telling you with the statute of limitations for minors, the 5 years does not begin to run on the statute of repose until, it can't extinguish until somebody is 10, okay? So if you were to, I'm trying to think of a case that would meet that. The important thing for you all is the 7 years old, right? There may be a case, and I can't think of one factually right now, that the statute of repose would bar something, but it can't bar something until the patient plaintiff is 10 years of age or older. Okay, so let's kind of get to what starts these cases and what you all as physicians may receive to start one of these cases. Not in every case. Some case the client comes to the plaintiff's lawyer so late that you're just scrambling to get a lawsuit filed before the statute of limitations runs. You're scrambling to get the expert review. You're scrambling to get the affidavit. But sometimes, and most times, if you have time before a lawsuit is filed, the attorney will draft something called a pre-suit demand or a notice of claim letter. That letter is actually going to be served in a lot of instances on you directly, or on your practice manager, or if you work for the hospital, if you're one of these OBGYNs that's employed by the hospital, it'll probably be served on your risk manager. But you are going, whether it's handed directly to you or handed to your office manager, it's going to get to you, right? And what that letter is doing is it's setting forth the facts that establish the basis for the case. And it's usually a letter that says, we're demanding that you provide us proof of your medical malpractice coverage, who the carrier is and what the limits are, so we know who to direct correspondence to going forward. That letter is also going to state the facts of the case, and then oftentimes that letter will have an invitation at the end of it that says, if you all want to discuss trying to settle this case short of litigation, give us a call, and we'll be happy to sit down. A plaintiff will always be happy to sit down and talk numbers. But the truth of the matter is most insurance companies, the work I did was mostly for the Doctors Company, TDC, and MAG. When I did this, they were the two biggest carriers in the state. But most of your insurance companies are going to make the plaintiff do their job, right? They're going to make sure the plaintiff is invested in seeing a medical malpractice case all the way through because they're challenging. They're going to make sure the plaintiff's lawyer is competent enough to handle them because it takes a skilled attorney to handle these cases. So I say that to say very few times is this letter sent, in my experience, very few times is this letter sent and a settlement subsequently reached within weeks or months. Typically the response is, thanks for the letter, here's proof of our coverage. Deny your request that we sit down and talk numbers at this point. We're going to make you jump through some hoops. We want to hear what your experts have to say about this. We want to hear what your client has to say about this. We want to make sure you're capable of handling it, that kind of thing. But the point of all this is do not panic if you receive one of these letters. You are going to get one at some point in your career. I promise you it's going to happen. You can be the best OBGYN in this room and somebody is going to find fault with something that you have done. It's just the way of the world. We live in a very litigious society and there's no shortage of lawyers out there looking over your shoulder, okay? I know that sounds scary, right? That you're constantly getting reviewed, your decisions are constantly getting reviewed, but these letters are written in the light most favorable to the plaintiff, right? This is a lawyer drafting a letter to set forth their case, and he or she is going to make that letter seem as persuasive as humanly possible, right? Because they're trying to convince somebody to come to the table and pay some real money. And you're going to read it and say, that's not true, or that's not how that happened, or man, they're attacking me personally, this is crazy. Just take a deep breath, okay? Get this to your insurance carrier, and your insurance carrier is going to assign it to defense counsel, and you'll have a meeting within a few weeks of getting one of these letters with your defense lawyer, and your defense lawyer is going to calm your nerves and say, hey, this was a tough case. There were some critical decisions that had to be made, and you didn't have a lot of time, and I can find an expert to defend this, most likely, okay? There are some cases that come in the door and you just wonder what the hell happened here. I can't find an expert to support this. Those cases are very few and far between. Almost every case will get assigned to a defense lawyer, and the defense lawyer is going to spend time with you strategizing on how to defend the case, okay? This is a thing that a lot of physicians typically ask me about. Consent to settle is a requirement in almost every single Georgia policy I've ever seen, okay? And what does that mean? What does consent to settle mean? It means when your policy was sent to underwriting and they drafted it, somebody put a consent to settle clause in it, which means neither your defense attorney or your insurance company can force you to settle. They can't settle your case without your consent, okay? The reason for that is if you do settle a medical malpractice case, there are things that your attorney and your insurance company are required by law to do. They're required to report it to the National Data Practitioners Bank, and they're required to report it to the Georgia Medical Composite Board, okay? So if we settle a case for you and make those reports, that can be harmful to you, right? So insurance companies have said, we will not do it without the doctor's consent. Okay, again, that's a benefit to you. And it's what I just said there. If consent is required, that means neither your carrier nor your counsel can force you to settle. That can be a tremendous headache for defense lawyers, right? I can't tell you the number of cases I have defended that have come in my door and I said, this is indefensible. We're not going to be able to find an expert to support this. If we go try this case, we're going to get our asses handed to us by a jury. And everybody sees it. I see it, the insurance company sees it, the experts see it, and the one person who can't see it is the named defendant doctor. And they'll say, I'm not giving consent, I don't care what you say. I've been confronted with that a few times in my career and been forced to trial a couple times in my career, and thankfully won those cases anyway and got a I told you so after the fact, but I say all that to tell you, if your attorney is telling you that the experts can't support the case, if your attorney is telling you this is a dangerous case for us to go try, this is a potential excess case, I think we should settle, you should really, I'm not saying you should always agree with your attorney, I'm not saying you should always do what your attorney says, but you should give that ample and adequate consideration, okay? If your attorney is telling you you got a case you should settle, probably means you should settle it, okay? It's not going to ruin your career if you give consent to settle, okay? I don't know the current requirements with the Georgia Medical Composite Board, but there's like layers of requirements. So if you have 3 cases that settle regardless of amount within I think a 5-year period, that becomes a matter of public record. If you have a case that settles over, I think, $250,000, that becomes a matter of public record. So the Georgia Composite Medical Board, they can discipline you, they can suspend your license in the worst of situations, which is like, molesting patients that have been anesthetized kind of stuff. They can revoke your license. They rarely do that. What they typically do is say, hey, we're going to make you take some extra CMEs on postpartum hemorrhages, and we're going to make you pay a $5,000 fine. Slap on the wrist, don't let this happen again. Sometimes the composite board doesn't do anything, but settling a case is not going to hurt you, right? And I don't know any patients that before they go see an OBGyn, they say, well, let me pull this person up on the medical composite board and see if there's any dings there. That really exists, I think, for attorneys, right? When I get a case in, I'll go see, has this doctor been sued before? Has this doctor had any recent settlements? Who is the medical malpractice insurance carrier for this doctor? It's a service for me, really. I don't think patients use it. But I think it can be far more detrimental to force your attorney to try a case that is not defensible, and then you get a big verdict against you, and everybody's scrambling about how do we handle this. If your attorney thinks the case needs to be settled and you can get it settled within your policy limits, that's why you're paying that big premium every month. Let your insurance do its job for you. Let your insurance protect you, okay? All right. After the notice of claim letter that we talked about earlier is sent, assuming that the other side doesn't say, okay, let's sit down in a mediation and talk, the next step is the filing of the actual complaint. Again, that's got to be served, well, it's got to be filed within the applicable statute of limitations. It needs to be served either within the statute of limitations or immediately thereafter. You have to show that you're being diligent trying to get the case served. Unless you tell your lawyer that you'll waive service, which I think in most cases you ought to agree to do that because they're going to get you served. You're going to be handed a complaint by a special process server or by a sheriff or by a deputy. It can be embarrassing. They may hand it to you at the hospital, right, in front of staff. If you want to avoid that, you can waive service and have your attorney acknowledge service for you, and that way they won't be sending folks out to try to track you down. And you'll know in most cases that this is coming before it comes. You will not know in most cases that notice of claim letter is coming. That's like the first thing that goes out that lets everybody know we have this case and we're going to pursue it. And then you'll kind of know that this is coming, and there'll probably be a discussion between the plaintiff's lawyer and the defense lawyer about this acknowledgement to prevent you from being served. Again, this complaint is going to be drafted in the light most favorable to the plaintiff. So take a deep breath after you read it. You're going to read it, and you're going to say, that's not true. How could they say this? How can they attack me personally? I know. I've sat with so many doctors and talked through a complaint with them. I know how offensive it can be. Take a deep breath. Schedule a meeting with your insurance company. Schedule a meeting with your defense lawyer. Talk to some folks that know how to defend these things, okay? It's going to be okay. With the complaints, oftentimes is written discovery. So let me start this part by saying the only currency that means anything in this game that I play, which is litigation, is credibility, right? If you have it, you can win your case, and if you don't have it, you're going to lose your case. It really is that simple. Credibility is the only currency that means anything in this world. And the way you gain credibility is you tell the exact same story every opportunity you get to tell your story. So the first opportunity you get to tell your story is in response to written discovery. These are written questions that are often served with the complaint. If they're not served with the complaint, they're served shortly thereafter on your attorney. And you have to sit down and answer them, and you have to sign a verification that says you've answered them truthfully, and the verification makes your answer sworn under oath. You want your answers to that written discovery to be very accurate, because then you're going to give a deposition later, and you want your deposition testimony to be consistent with what you said here, right? And then if your case doesn't settle, you're going to end up in trial, and you want to have what you tell the jury consistent with what you said here and with what you said in your deposition. So this is kind of the launching point of this is my story. This is how I'm going to tell my story, okay? You need your story to be consistent, so it's got to be right out of the gate, or we're going to have problems, right? You sit down with your attorney. You don't tell your attorney an important fact, right? Your attorney doesn't disclose it in written discovery. All of a sudden, before your deposition, you start thinking about it, and you say, damn, I wonder if I should have told Slade, right, that whatever the fact is, and now I've got to start explaining to the other side why we weren't truthful. You've lost your credibility. Right? And when you lose your credibility, I can't do anything for you, okay? So it's very important that when you sit down with your attorneys to answer these written questions that you are honest, like completely honest, like filleted open on the table honest, okay? I was divorced 10 years ago. I got a DUI 8 years ago. Whatever. I was charged with armed robbery, but the charge was, I was not convicted, and I was told the charge was expunged from my record. However irrelevant you think it is, you tell your attorney and you let him decide if it's relevant, okay? And you do that at the outset of the written discovery process. After you answer questions in writing, then you will give a deposition. Your deposition will be an opportunity for the lawyer on the other side to swear you in front of a court reporter and ask you questions in a face-to-face environment. Most depositions today are being done by Zoom, except in medical malpractice cases. We're still doing these in person because these are, valuable cases. They're important cases, and people want to be in the room with the folks they're deposing, and they want to assess them as witnesses. The other side, when they are taking your deposition, is doing a couple things. They're asking you questions that they already know the answers to because they've served you written questions and you've already answered them there. They're going to re-ask you those questions because they want to make sure you're consistent, okay, that you're telling the same story. They are also gauging you as defendants. What kind of defendant is Dr. Champa Woodham going to make if I put her on the stand? Is she going to hurt me in front of a jury? Is a jury going to like her? Is a jury going to be compelled by her story? Is a jury going to believe her? Right? This is all what the lawyer asking you questions is processing during your deposition. This typically occurs 90 to 120 days after the lawsuit is filed. Again, it'll be your second opportunity to tell your story. First opportunity is written discovery. Second opportunity is depositions. We've got to be consistent so we can maintain credibility. I believe this date in your case, when it comes, is the most important date in your case, unless we end up in trial. And then those days that we spend in trial will become the most important. For that reason, when I defended these cases, I would spend days sometimes with my doctor. If you don't feel like your defense lawyer is spending enough time with you on your deposition, tell your defense lawyer to do their job, okay? You do not want to walk into a deposition not feeling comfortable with everything, right? And so that's what I tell all my doctors. We're going to sit down and practice. We're going to go, I'm going to tell you, like my job as a defense lawyer, I believe, is to predict every question that the other side may ask and tell you that it's going to be asked and rehearse your response, okay? And if we can get that done and get ready in 3 hours, great. But my experience, that's more like 2 days. I've spent a week with a doctor before. If the case was bad enough and the deposition was going to be challenging enough, we spend as much time as we need to make sure you're ready. But the onus should be on your defense lawyer, but if you don't feel like you're getting adequate prep, reach out to your insurance carrier, tell them that, work with your defense lawyer, tell them you want more prep. Okay, if the case, so there's going to be the pre-suit demand letter that I talked to that's probably going to be ignored. Nobody's going to sit down and settle the case then. Once you take the depositions of the parties, before you move to trial, there's kind of a downtime in these cases where the doctor's been deposed, the plaintiff's been deposed, anybody else involved in the surgery, maybe a circulating nurse has been deposed, whatever. Office staff has been deposed, but we call that depositions of the parties. And you do that before you take the depositions of the experts, because the experts are then going to get the transcripts of what you say in your deposition, and the plaintiff's expert's going to review it and say, I can't believe Dr. Champa-Woodham said this in her deposition. I'm gonna crush her on this at trial. Or, hopefully, man, Dr. Champa-Woodham really explained this well in her deposition. She's going to hurt us at trial. But there's usually a downtime between the depositions of the parties and the depositions of the experts. That's where a lot of cases settle, right? Because once you plunge into experts, you're pretty much committing to going the whole way, and the whole way is here, right? So then once you get through expert depositions, if the case doesn't settle, you actually have a trial. The first medical malpractice case I ever tried was 10 years old, right? I started as an associate with a firm. It was just one of these cases that was collecting dust in the corner. The doctor wasn't paying attention to it for whatever reason. The partner wasn't paying attention to it. I picked it up, tried it 10 years after the date it started. That should never happen, right? Typically, it's 2 to 3 years. 4 years is not uncommon. Some of it depends on the court's docket, the availability of the experts kind of thing, but you're typically looking at 2 to 4 years is probably more accurate here, from the date the case is filed until you get your trial date. Typically, a medical malpractice case is specially set, meaning you don't have to wait in line with everybody else that's trying to try a case. You can tell the court typically, will you give us a week certain that we know is our week so that my doctor can take time off? It can be hard for doctors to try cases, right? So that my experts can make plans to fly in from California, wherever they are. So typically you get a specially set week, and typically they last about a week. Really complex ones can take 2 to 3 weeks. Once we sit down at trial, this is the process. We go through something called voir dire. Y'all probably heard of that in some of these lawyer shows on TV. A lot of people are mistaken that we choose jurors. We don't, okay? We ask questions of jurors that are intended to expose their bias, right? If a juror has had a bad outcome with an OBGYN, right? We want to know that in voir dire, and then we're going to use one of our strikes to strike that juror to make sure they don't end up, because that juror is going to be biased towards you as an OBGYN. So both sides typically get 6 strikes, and then you take what's left over. So I would strike 6, and if I was defending the case, the plaintiff would strike 6, and the 12, we would strike those from the first 24, and the 12 that are left are our jury. Then we'd move into opening statements. Plaintiff always puts their case up first. Plaintiff makes an opening statement, defense makes an opening statement, and then we move into the plaintiff's case. This is where the evidence is admitted, and this is where the plaintiff patient, the person criticizing you, will take the stand. And then after that, we move into the defendant's case, and that is when you take the stand. In the plaintiff's case, the plaintiff's experts will take the stand, and in the defendant's case, the defendant's experts will take the stand. And then we do closing arguments, request of charge, or that's the court telling the jury the law, and then the jury goes and deliberates, and then the jury renders a verdict. All right, the burden of proof in a trial is on the plaintiff, meaning you can win a medical malpractice case without tendering the first piece of evidence. You can, what I call poking holes. You can sit on the defense side and just poke holes in their case, right, without putting any evidence up of your own. In a good case, you want to have really good defenses and you want to tender your own evidence, but you can win a case on the defense side without putting up any evidence. The burden is on the plaintiff, and that is a preponderance of the evidence burden. And so if you think of the Lady of Justice holding the scale, right, a preponderance of the evidence, y'all are probably not going to like this, but that is just a tipping of the scale, right? That is from 50% dead even to 51-49. That is enough for the plaintiff to meet their burden. In a criminal matter, that burden is beyond a reasonable doubt. Right, and I'm sure y'all would all like that to be your burden, but it's not. It's preponderance of the evidence in a civil case. In a criminal matter, it's heightened because you don't want to throw somebody in jail unless you're beyond a reasonable doubt that they're guilty of the crime. You still have to convince 12 people, right, by preponderance of the evidence. The verdict has to be unanimous. So it's still, even though it's just a tilting of the scale, it's still, in my opinion, a hard burden to meet. I also believe, and you heard Champa say, I call her Champa, just can't help it, but you heard Dr. Woodham say when she was introducing me that I have never lost a medical malpractice trial. That is true, and while I would like to toot my own horn and say that was all due to great lawyering, the truth of the matter is it is very hard to win these cases as a plaintiff. You do not walk into a courtroom on level footing with a physician. You just don't, right? Because why? Why is that? Because you all have spent the better part of your lives training for this job, right? Most of you started paying really hard attention to your studying in high school, right? And then you went to college, and then you went to med school, right? And then you took step 1 and step 2 and step 3 and step 4, and then you went to residency, and then however many steps there are. My wife's laughing at me. But anyway, you have done all of this work to become the expert in this field, right? And so you walk into that courtroom in an elevated spot to the plaintiff. And that's just the truth of the matter, right? And so when I have won cases for doctors, a lot of it had to do with the fact that they walked in that courtroom at an advantage over the plaintiff that was criticizing them. And we took advantage of that for the doctor. And we did do some good lawyering, but by and large, these cases are very hard to win from the plaintiff's side. And if they are winnable from the plaintiff's side, they're probably going to settle, right? So the cases that I did try and win, with the exception of 2 where the doctors wouldn't give us consent and we won anyway, they were all really good cases. So don't need to toot my horn too much on that. There is something now in Georgia called apportionment. It used to be in Georgia something called joint and several liability, meaning you could have 10 defendants on the defendant side of the V. You could have the hospital, an MFM, an OBGyn, a primary health care provider, nurses. You just had this ledger of defendants, and the jury would just enter a verdict. They could just enter a verdict for $10 million, and the defendants had to figure out, how are we going to pay this verdict, right? And a lot of times the hospital would step in because they have these big, reinsured policies, and they would pick up a chunk of it. And anyway, there was always some work to do on the defense side going, how are we going to pay this big tab? Now, jurors have to apportion cases, meaning On the verdict form, if there's multiple defendants, there will be a place by each defendant. And so they'll give a big number, whatever the number is, let's say it's $10 million, and then they'll say, and we apportion 5% of this to Dr. Woodham, 5% of it to Dr. Cohen, 75% of it to the hospital, and the other 20% to these nurses. But they're required to actually sit it out in an apportioned verdict. All right. How can you protect yourself? So let's start by this conversation that I've had with so many doctors. Do I need to put everything in my spouse's name, right? Do I need to not have any assets? Do I need to not be on the house? Do the vehicles need to be in my wife's name and my husband's name? Like, what do I need to do here? You can do those things. I'm not a financial advisor. I'm not here to tell you not to do those things, but I am here to tell you that my father did this for 40 years before me. I'm now, can't believe it, 20 years into this career. My father has never seen it, and I have never seen it, where a doctor lost their assets from a medical malpractice case. I'm not saying it can't happen, right? I'm not in here telling you it can't happen. I do not want somebody to come up to me crying 10 years from now saying, I lost everything and you said I wouldn't. I'm not telling you that. I am not telling you that, but I'm telling you, as a practical matter, it does not happen, okay? The plaintiff's lawyers that take these cases are typically not in it to ruin doctors' lives, right? They're typically going after the insurance money. Most plaintiff's lawyers don't want to chase people around and, levy on their house and levy on their vehicle and that kind of thing. But there are some real pricks in this field, and there are some folks that would relish in the opportunity to do that to you. And so I'm not telling you it can't happen, but it rarely happens. And in 60 years combined between my father and me defending these cases, we never saw it happen once. Okay, so just to give you an idea of how rare it is. But there are ways that if you're going to trial, you can protect yourself. Okay, and one of them is something called a hammer letter. Anybody here ever heard of that? Raise your hand if you've heard of it. Okay, a few people have heard of it. A hammer letter is a letter that independent counsel would write to your defense lawyer. And it would be a letter from that independent counsel saying, I have reviewed the case against Dr. Woodham. I am concerned that this case creates an excess exposure. An excess exposure means it could result in a verdict in excess of her medical malpractice insurance coverage. I'm concerned this creates that exposure for her, and I am demanding that you pay her limits in exchange for a release that will release her individually so that they cannot come after her. All right? And an insurance company may get that and still not pay her limits. They may still be so confident in the defense and their lawyer's ability and their expert's ability that they have that letter and they stick it in the file and they still don't pay limits and you go to trial. If they have that letter in the file and Dr. Woodham's got $2 million in coverage and there's a $5 million verdict, so there's a $3 million excess, if anybody comes to get that against Dr. Woodham, she can say, we sent you this letter telling you to pay this policy coverage that I bought for my protection, and we demanded you pay it, and you didn't. So you, MAG, you doctor's company, you pick up this excess verdict, not me, right? So that's one way to protect you. Now, I've had it many times in my career where a doctor wanted the benefit of this letter, right, the protection that this letter can afford, but they didn't want their case to settle, right? Their belief was, I haven't committed malpractice, I want my day in court, I want my opportunity to defend myself, but I also want this protection, right? The advice there is you can send that letter and get that protection, but once the insurance company has it, remember we talked about consent earlier? That letter qualifies as consent. When your attorney writes a hammer letter, it's not only are they saying Dr. Woodham consents to this settlement, they're saying Dr. Woodham demands this settlement, right? So that is giving consent. So if you send it, your insurance company may very well turn around and cut a check for your limits. If they don't, though, I've tried a few cases where we had these in the file. Those are the best cases to try. I know my doctor is protected, right? I know if we get a big verdict against us, MAG or the doctor's company or whoever is adjusting this particular case can handle it, right? Nobody's ship is sinking on my watch here. Those are the best cases to try on the defense side. Another mechanism that you can pursue to protect yourself is something called a high-low. And a high-low agreement is basically numbers that are put in place that regardless of the verdict, those numbers are going to be in place. So you may have a high-low, let's say, again, I just keep using Champa, but let's just say Dr. Woodham's got $2 million in coverage, and there's a case that she's going to trial with a defense lawyer, and the case looks real defensible. They may pitch a high-low that basically says, even if we win the case, right, we get a defense verdict, the low is going to be $200,000. So we would even if we win the case outright, we'll have to pay you $200,000. In exchange for that, y'all are putting a high on this thing at $2 million, the top of her coverage. So even if y'all go get a $10 million verdict, the most you can collect is $2 million, right? That is, and those things are hard to negotiate, right? You can imagine why. But if you can get one in place and the high is within the applicable coverage available, that would also provide protection from any kind of individual exposure. That is typically a part of this presentation that draws some questions or some comments. Does anybody want to ask anything about that before I move on? Anybody have a comment about that? Yes, ma'am. No, the jury is not told about a high-low agreement. They're not told about a hammer letter. The jury is not told about insurance. So you would try a case in front of a jury without the jury knowing that you have medical malpractice insurance or knowing the limits. At the same token, a defense lawyer can't get up and when a plaintiff admits a bunch of bills for a revision surgery and they say, I have $200,000 in bills for this surgery, I can't stand up as a defense lawyer and say, well, you had health insurance with Aetna and Aetna paid all that, right? So matters of insurance are not admissible at trial. Neither are any of these agreements that are typically insurance driven to protect folks, but matters of insurance are never admissible at trial.
In the interest of protecting ourselves, for those of us who work for large healthcare entities that supply our malpractice and our lawyers, should we also retain our own lawyer who we are their only interest in the hospital, et cetera, or not their interest?
So you certainly can, but that would be an expense to you, right? And that's probably going to be an hourly expense. The lawyer that you retain to do that is going to do it on an hourly basis and probably charge you, depending on where you are in the state, somewhere around $250 to $300 an hour. And so those bills can rack up and accumulate pretty quickly. I would say that whoever you retain is probably not going to be as good at it as whoever the hospital assigns your case to. And in most cases, the hospital and you should be like united in your defense of the case, right? Like if there's a case where you feel compelled to criticize the hospital feels compelled to throw you under the bus, which your lawyer should work really hard to make sure that doesn't happen because that doesn't help anybody but the plaintiff. But if you're in a factual situation like that where you're worried about something like that, then you probably should get your own lawyer. But for the most part, everybody should work to be a team, to put up what we call a united defense, and the defense lawyer assigned to you by the hospital is going to be the best one and the most qualified one to do that for you. But you certainly can go get your own lawyer anytime you want to. That's a great question.
Can a high-low agreement be negotiated at any point in the case?
Certainly can, but in practicality where you see them is usually during the trial.
Is it an obligation that as a defendant you're aware of the high-low agreement? I feel that in the case I was involved with, there was a high-low agreement that I don't feel maybe we knew about.
Well, I don't want to cast aspersions here, but I would certainly tell my doctor about a high-low agreement if I was sitting there with them. One, it gives you the peace of mind of knowing it's there, right? That's to me, that's the whole incentive to negotiating it. How can I make my doctor as comfortable as possible? It may not feel this way because I do plaintiff's work now, but I'm very pro-doctor, right? And so when I defended these cases, like my feeling was my job is to make my physician who's going through this foreign process that they're not used to as comfortable as possible. And if I can negotiate a high-low and that provides my physician protection, I should do that for them so long as my insurance company agrees with the numbers. And then I should communicate that to them so they're aware of the protection they have. To me, it would be pointless to have it and not have them be aware of it. I'm not sure why that was not communicated better to you.
Is it a decision that's made between the insurance company and the defendant attorney, or is it a decision that the defendant is actually involved in?
It's made between the defense lawyer and the plaintiff's lawyer, but it's got to be agreed to by the insurance company. You, as the defendant doctor, don't have any input other than to say, hey, I want a high-low if you can get it, right? You can kind of charge them to go try to negotiate one, but your insurance company may say, we don't have any interest in that, or the low number they're seeking is higher than anything we think we're going to win this case, so we don't want to have a $250,000 low on a case that we think we're going to get a defense verdict, so it's just not going to work out. But you can ask, right? And you should ask if you feel compelled.
You can't reject the high low though.
You don't have the authority to tell your defense lawyer, turn that number down, right? That's going to be a conversation your defense lawyer has with the insurance company that's responsible for the money. But you should be involved in the decision-making process to the extent that you're telling your attorney, I like this or I don't like that, and your attorney should consider that, right, in the negotiations, but you don't have the authority to stop it or start it or agree to it or not agree to it.
Hello.
Yep.
In 2005 and 2006, we worked very hard at the state legislature to pass some meaningful tort reform. Most of these things have been eaten away and beaten down and are less effective now. And this may be a hard question for a plaintiff's lawyer now, but do you see any opportunities where we can work for some meaningful tort reform in the upcoming legislature? So
it's a very interesting question, and it's one that we could probably bore everybody to death sitting here talking to each other about it for hours. There's always opportunity there. The problem, as this room would see it, is the plaintiff's bar is very powerful, right? The plaintiff's bar has a lot of money. It's a very powerful bar. It's got a lot of influence over its legislatures. And if you are successful in getting some tort reform legislation passed, as you mentioned, they're going to pour a lot of time and money in trying to eat at it, right? And over time, a lot of that protection afforded will erode away. What you see in a lot of other states, what you see in South Carolina, which is where I am now, you see caps, right? So for pain and suffering, the court may say the most you can award, I think in South Carolina, don't hold me to this, but I think it's like $500,000, or maybe it's $250,000 per party, up to $500,000. So you can put caps on damages, right? In Georgia, there are no caps. So a pain and suffering claim, and nobody knows what this means, but it's whatever is in the enlightened conscience of an impartial juror, right? So a juror can say, I believe that pain and suffering claim is worth $100 million, right? And if they can convince the other jurors in the room that that's what they should award, they can award it. Now the court may write that number down if it shocks the conscience. There may be some ways to write it down, but there's no cap. There's no automatic, hey, that 10 million or 100 million becomes 250,000. In some other states there are. I used to always caution defense lawyers, and this might sound a little bit greedy, but to be careful promoting tort reform, right? Because you make your money defending these cases, and you want to be in a place where people want to bring cases so you have something to defend, right? So there's a catch-22 there too, that if you get all these caps in place and you get all this protection for defendants, which is something you all want, as a defense lawyer, it could be harmful to you because now you've created a venue that's not very desirable to litigate in, and you may be sitting there watching the clock turn without having any time to build to it. But that's a great question. I don't know if that answered it at all, but it's a great conversation that we could have.
We've got one more for the audience and then one from our virtual audience.
Great, okay, yes ma'am.
So I might have missed this part, but if you're a private practicing physician and you have your malpractice insurance and then you get served, are they providing you a preferred attorney, or you can just get your own attorney? Like I have the doctor's company. So because my question is that if they have a preferred attorney or something they work with and you want a hammer letter to protect you from anything else, why would their attorney try to protect you so that they would pay anything in excess?
Okay, so it's a great question, and it's a bit of a complicated answer, so just bear with me. So you said you're insured by TDC, right? So TDC has, and there's TDC reps in here, I don't want to misspeak on TDC's perhaps. Let's use a John Smith insurance company, so we're not talking about, let's just say John Smith Insurance Company insures you. John Smith Insurance Company is going to have a bunch of lawyers or law firms in the state that are on its approved list. These are firms that we have approved to represent John Smith insureds in medical malpractice cases. My firm, when I did defense work, was one of those. It was called Martin Snow, and we were approved for, let's just say, John Smith. So your case, when you get served, is going to go to one of those approved lawyers, okay? and that person is going to defend you. They have something called a tripartite relationship. So they have a relationship with you, and they have a relationship with John Smith Insurance Company. They're required by law to give your interest paramount consideration, meaning if there's a decision that has to be made and they're having trouble deciding, is this best for my doctor or is this best for the insurance company, they're required by law to make the decision that's in the best interest of their doctor or their insured, okay? And they're required to constantly be thinking about protection for you, right? That's how the law lays it out. That's how it defines a tripartite relationship, is that you have to give your individual insured or your defendant doctor's interest paramount consideration. So that firm that's on the approved list should be thinking that way, and they're ethically required to think that way throughout the entire process, right? That person, though, is employed by the insurance company, and they're not going to write a hammer letter to their own insurance company. So you would go to another lawyer and say, address this letter to my John Smith Insurance Company approved lawyer and tell him that or her that you're demanding that they pay limits. And that lawyer will forward that up the chain to the insurance company, and somebody at the top of the insurance company is going to say, okay, now there's another lawyer looking after the individual personal interest of this doctor who's demanding we pay limits. Should we do it or should we not? Right? And in some situations, the doctor doesn't even want them to pay. They just want that letter in the file for the protection. Right? Did that answer your question? Yes, ma'am.
And from our virtual audience, Jennifer Allen wants to know, if high-low and you win, does the data bank still find out?
Oh, that's an excellent question. The answer is no. If you have a high-low in place and you go get a defense verdict, that's a defense verdict for reporting purposes, right? So the Medical Composite Board, neither the Georgia Medical Composite Board nor the National Data Practitioners Bank, we're not required as attorneys to report that, and the insurance company is not required as insurers to report that. So that is a defense verdict. That's a win. It doesn't tarnish your record, but the plaintiff is going to get the windfall of that $200,000, $250,000, whatever the number is on the low. They'll get that, but not to your detriment. Yes,
Thank you.
I think we're going to go to the next, because I'm walking behind. We're going to stop questions for a second.
Yeah, yes, okay. Sorry, I didn't realize I was out of time. So I'll go really quick. I'm at the end anyway. So how can you prevent yourself from being named in a medical malpractice lawsuit? One thing I tell every doctor, and I've said it a couple times in here, it's going to happen. No matter what you do, it's probably going to happen. We live in a very litigious society, and it's just probably going to happen. But you want to document, and you want to document intentionally and intelligently, okay? You want to communicate. I can't tell you the number of cases now that I'm on the other side, right? I can't tell you the number of cases I get called about, and I have to tell the person, this is not malpractice, right? You're not the victim of malpractice. But the reason they're calling me is there was a communication breakdown, and they felt like their doctor mistreated them, was not compassionate to their condition, right? Was not attentive, was not paying attention to them. Don't do that. Don't give your, and most of you won't, right? Most of you are in this to help people, and you know better, right? But we all get busy, right? And we all get distracted, and we all let things fall by the wayside, but communicate. Treat your patients the right way, and they're going to be less inclined to want to see you if something does go wrong, right? Rely on your training. I said it earlier, but you all have spent the large part of your adult life training for what you do. You're qualified to do this. Rely on your training. This is a question that we used to have doctors ask when we were preparing for depositions. Is it better to do something than do nothing, right? If there's a case that this requires maybe some evaluation, we want to sit and watch this patient and see how they progress. Is it better for us just to do something so somebody can't come back and say you did nothing? The answer to that question is you need to do whatever the whatever your training and the literature suggests you do, but if the answer is to do nothing, right, and evaluate, and let's sit and see how this patient does, while we give fluids or whatever you may be doing to see if the patient just kind of naturally improves, document while you're doing nothing, right? Don't have a file or a chart that's got nothing in it. If you're making a decision to do nothing, put it in the chart. Why are you making that decision? And then you're going to protect yourself from malpractice later. All right, I had a couple of cases that I was going to go through, but I don't even think we need to do that at this point. I think I'm over time. Are we? How many slides do you have? It's just like a couple. You want to do one case? Okay. Okay, we'll do one case. This is a case that I actually tried, and it's a case that I thought had some problems, but it's a PPROM case. This lady was 25 weeks pregnant, and she was leaking some fluid. She went to an OBGyn. This was down in South Georgia. I will obviously keep the OBGyn nameless here. But went and actually saw his PA, not the OBGyn. She looked for pooling, did not see any pooling. She did a Fern test that was negative, and she did a nitrazine test, which I haven't had this case in a while, but doesn't it turn blue if it's amniotic fluid? Okay, so it was a nitrazine test, and it was in a medical record, and for some reason somebody selected green. And I think it was the way the record was set up that anyway. The other side took it to be an equivocal nitrazine test, right? And she was leaking amniotic fluid. You all didn't diagnose it. And then within a few days of their alleged failure to diagnose it based on this equivocal nitrazine test, she had a 25-week footling breach and lost her baby. Anybody want to take a guess as to what happened in that case? Okay, I tried it, and we won it over a week-long trial. Just to give you an idea of how these cases can go, I tell folks all the time, they often are not about the medicine, and they're often not about anything other than who the jury likes and who the jury doesn't like, and part of our job as attorneys is to figure out how to push those buttons. In this case, unfortunately for her, we learned that this woman plaintiff was in a cult. And part of the cult is to entice it's like a sexual cult, and they attract other people to join this kind of sexual community. And she had had a prior LEAP procedure that she had not revealed, right? And we were able to get the cult stuff into evidence and talk about the LEAP procedures, explaining her 25-week footling breach. And we convinced the jury that she was crazy, and we won the case. And it had nothing to do with the medicine, right? So that was some good lawyering. All right. Thank y'all very much.